All right. I think the first panel deserves another round of applause, right? Thank you so much, panelists. Before you earn the right to go for a coffee break, we have one other panel. Yes, the panel that is going to discuss the topic, the battle of the Titans, enforcing an arbitral word set aside at the seat. And may I take this opportunity to welcome the moderator of the panel, Mr. Thierry Ngoga, our partner at Legal Line Partners Rwanda. Please, you're welcome. Introduce your panel, and of course, people are looking forward to the healthy break. Thank you.
Thank you. Both of them doesn't need any introduction. Join the stage, Professor Emilia and Dr. Selim. Good morning again. Good morning.
Good morning.
This morning, we are going to discuss enforcement of an arbitral award set aside at the seat. It's not by accident that the speakers are two academicians. The reason being, it is the two contrasting positions have been debated for decades by academicians. That's why we have Professor Emilia. We don't need your introduction. She's a professor of international commercial law at SOAS University. For details, you can check at page 12. And we have Dr. Ismail, who is the director of KIAC in Cairo, Egypt, and teach international arbitration. For more details about Selim, you can check at page 13. As I said, there is a contrasting position taken by a number of arbitration jurisdictions in relation to the enforcement of awards that have been set aside at the seat. The two titans today will discuss the two contrasting positions. If I may anticipate, the international one of the positions being that the International Arbitration Award is an international decision grounded in a non-national arbitral legal order, and therefore, can you put the light, please? I'm old enough to not reading in the dark. Please put the light. It's dark, it's too dark here. Okay. I find a solution. So I was saying that one of the positions being that the International Arbitral Award is an international decision grounded in a non-national arbitral legal order, and therefore its annulment by a state court has no bearing on its enforcement in another state. There are so many positions on that, including Putrabali case, which many other cases will be discussed by Selim in regard to the French doctrine on this. And on the other case, the other approach being that the seat answers the arbitration to the legal order of the state in which it takes place. In another word, when when the seat have set aside an award, it's over because the award does not exist anymore. That is the other approach, which will be discussed by Professor Emilia, being mainly common law or Anglo-American position, whatever you call it. So, what are we expecting from, mainly the question we are expecting to be answered by the two titans is that we will be exploring how courts in different jurisdictions approach the issue. Then the panelists as well will use mainly the Article 5, 1E, and 7.1 of the New York Convention. I hope it is projected there. We have asked to project the two articles. But most importantly, the panelists will discuss whether the African court should follow the French doctrine or the opposite. Again, they will also discuss the possibility for enforcing an award set aside at the seat, whether African seat in that situation can refuse. What does it mean for African seat? I may now start by by Dr. Selim, who will take the position of yes, and which is the doctrine of the French doctrine on this issue. Thank you very much, Professor. You want to come here? Yeah. Oh, come.
Good morning, ladies and gentlemen. Can you hear me well? Okay. So it's my pleasure to shed light on the position of French courts regarding the enforcement of arbitral awards having been annulled at the seat. I have chosen to shed light on this position perhaps because of the fact that I studied in France and my PhD was from France, and it has affected my way of thinking, even if I will not take a radical position on that. And then at the next round, I will be happy to discuss how can the African states benefit from adopting such a position. Another radical position that I would like to mention before getting into the French position is the position of German courts. German courts deny enforcement of an arbitral award that has been set aside at the seat because it considers that once the arbitral award has been set aside at the seat of arbitration, it does not exist anymore. It's not valid. It's not valid, so it cannot be enforced elsewhere. So that is a radical position of the German courts. The position of the French court is not the opposite. So we are not suggesting here that any award set aside at the seat will be automatically enforced in France. This is not the position. Indeed, the award shall fulfill an award set aside at the seat, for example, an award that has been annulled in Egypt, to be enforced in France. It shall fulfill the requirements of an arbitral award, a foreign arbitral award, to be enforced in France. These requirements are set forth in Article 15, 14, Article 15, 20, and 15, 25 of the Code de procédure civile, which regulates arbitration. So there are 5 grounds for refusal of enforcement under the French arbitration law. If the tribunal has wrongly upheld or denied jurisdiction, the tribunal was not properly constituted, the arbitral tribunal ruled without complying with its mission, and if the arbitral tribunal did not respect due process or the principe de la contradiction, or if the award is contrary to the French conception of international public policy. So if an award is set aside by the seat and the interested party is seeking its enforcement in France, it shall fulfill these conditions. Why do the French courts permit the enforcement of arbitral awards set aside at the seat? Because of their construction of Article 5.1e of the New York Convention combined with Article 7, and you can see both of them. So according to the French and I think the other jurisprudence or state courts of other countries as well, Article 5.1 of the New York Convention is to be construed as providing for a permissive standard according to its wording, because it provides that recognition and enforcement of the award may be refused. It's not shall be refused. It's may be refused only if. So it sets forth a maximum ceiling of control, but any country may reduce the level of control and may permit the enforcement of an award even if one of the grounds for refusal under Article 5.1 of the New York Convention is present. So according to the French courts, and I will cite you some case law, the fact that an arbitral award has been set aside at the seat is not a ground for refusal of enforcing an arbitral award in France, because it's not one of the 5 grounds for refusal that I have just mentioned. And this would suffice in itself to permit such enforcement of a foreign arbitral award that has been set aside at the seat. However, in many of the case law that I'm going to cite, also the Article 7, Paragraph 1 of the New York Convention was also relied upon by the French courts. The Article 7.1 provides that if the law or a convention or a treaty of the state where the arbitral award is sought to be enforced or recognized, if such law is more permissible and is less stringent than the New York Convention, than Article 5 of the New York Convention, then it's the less stringent law that is going to be applied. So the French arbitration law is setting forth only 5 grounds for refusal of enforcement and is less stringent than the New York Convention, so it applies, and it excludes the ground for refusal mentioned in Article 5.1e, which is the award being set aside at the seat. So there are a series of decisions beginning. It didn't begin from Hill-Marton and Cromoloy. There is a more, an older decision, which is as old as 1984, which is the Norsolor case. And the Norsolor case concerned an arbitral award that was set aside in Vienna. So it was not set aside in Egypt or in another African state. It was an award that was set aside in Vienna. Usually, you will see that usually these awards that were set aside at the seat and were then enforced in France, the reason for setting aside such awards was either for domestic reasons or local reasons, such as domestic public policy or domestic provisions regulating arbitrability, or because the judge of annulment has revisited the merits of the case. So, for example, in the Norsolor case, the arbitral award was set aside because the arbitral tribunal applied the lex mercatoria instead of applying the conflict of law rules that the tribunal shall deem appropriate, and then the conflict of law rule would determine an applicable state law rather than the lex mercatoria, and the judge of annulment considered that this was in violation of the then Article 13 of the ICC rules which provides that the arbitral tribunal, in case the parties do not agree on the applicable law, should determine a conflict of law rule that it deems more appropriate and then designate an applicable law. So we see this is not a standard or a reason for refusing the enforcement of an arbitral award in France. The next famous case is the Hill-Marton case. And same as the Norsolor case, the arbitral award is, that is rendered at the seat of arbitration is not considered as an integral part of the legal system of the seat. That's why the French courts consider that even if such an arbitral award is annulled, it can still survive and it can still be enforced in France because it does not constitute an integral part of the legal system of the seat of arbitration. So an arbitral award issued in Vienna, the case of Norsolor, or issued in Switzerland, the case of Hill-Marton, it is not anchored in the respective Austrian or Swiss legal system. It is autonomous from it, so even if it is annulled, it can be enforced in France. And this is different from the position of German courts, which consider that such an arbitral award is part of the legal system of the seat, so its annulment means that it is not valid anymore, and an award that is invalid cannot be enforced in Germany. Then there are other interesting case laws, such as Kromoloi. Kromoloi pertained to an award that was set aside in Egypt because the arbitral tribunal applied the Egyptian civil law instead of applying the Egyptian administrative law. So this is also a sort of revision of the merit, and this decision of Cairo Court of Appeal was criticized in Egypt and was in the later jurisprudence of Egyptian courts was not reinstated or reapplied, but the Egyptian courts have changed their position and considered that this would be a revisit of the merit of the award. Another interesting decision this time was the decision to enforce an award in France issued in the UAE, in the Emirates, in Dubai. It was a dispute, it was an arbitral award rendered in favor of Bechtel against the Department of Civil Aviation in the UAE. At that time, the UAE was not a party to the New York Convention. So the New York Convention was not mentioned at all here. So we are not talking about Article 5.1e or Article 7, Paragraph 1 of the New York Convention. This time, the French courts have applied the same principle, but without mentioning the New York Convention, and just stated that not considering the annulment of an award at the seat as a ground for refusal of its enforcement in France. This is a fundamental principle of French arbitration law. And the award was enforced. And we will see that the reason for the annulment of that award in the UAE was a purely domestic reason. And this award was annulled because the witnesses testified without being under oath. So this was considered as contrary to the UAE public policy, but it is not contrary to the French public policy. And the French judge does not have an obligation to defend or protect France from violations of the Emirates' public policy. What is interesting in this decision was that it was enforced based on the bilateral treaty between the UAE and France, a bilateral judicial cooperation treaty. And in this decision, the French Court of Cassation considered that a judicial decision in the UAE or elsewhere deciding to set aside an arbitral proceedings is limited in its effect within the territory of the country that has issued the setting aside decision. So a decision by the UAE courts is limited in its sovereignty within the territory of the UAE. So the award is not linked to the legal system of the country that has decided to set aside the award. The decision of the judicial body that has set aside the award has a limited territorial effect and does not bind France. Third thing, the arbitrator, this has also been decided by the French Court of Cassation in other decisions. The arbitrator that has issued an arbitral award seated, for example, in Egypt, is not linked to Egypt, because unlike Egyptian judges who are linked to their country, an arbitrator also is not linked to the state in which he has issued an arbitral award. So this is the delocalization of, this is the doctrine of delocalization of the arbitration. In France, Emmanuel Gaillard believes that there is an ordre juridique arbitral, so a separate arbitration legal system that is detached from any state. What is interesting, and I will finish here, I know 2 or 3 minutes pending. The most recent case where an arbitral award set aside at the seat was enforced in France is the EGPC versus NatGas case, and this is an arbitration that took place in Egypt under Corsica rules, and the French Court of Cassation considered it as a domestic arbitration. So it was an arbitration between an Egyptian private entity and an Egyptian public entity. So in this case, what is interesting and what has been criticized by Éric Loquin, my professor who supervised my thesis, that the French Court of Cassation mentioned that it can enforce an arbitral award set aside at the seat, so a foreign arbitral award, irrespective of whether the arbitration is domestic or international. So an arbitration can be foreign vis-à-vis France, but domestic. And this has been criticized by Éric Loquin because the French approach is based on the fact that an arbitral award is completely detached from the legal system of the seat. How can we apply this on a domestic arbitration award? So this is a question mark. We leave it open, so this summarizes more or less the French approach. Thank you very much.
Thank you very much. It's just to remind you that this is a debate. So it doesn't mean that the views we express individually is what we actually believe, but our job is to convince you one way or the other. So I'm going to start by asking you a question. What is the purpose of going to arbitration? Is to get an award. What do you want to do with that award? You want to transform the number of pages of paper into money or asset or property. How would you do that if the other party does not willingly make payment? That's why we have the New York Convention. The New York Convention, the idea with the New York Convention is respect, mutual respect, comity between states, member states of the New York Convention, of courts, of the, of states of the New York Convention, and that's why we have Article 5.1e. We have Article 5.1e so that if a court of competent jurisdiction has looked at the award, and for whatever reasons, if it falls within those grounds or not, Ismail is explained to us why not. They set it aside. And when that award is set aside, the question then becomes, or when it is annulled, the question then becomes, is there anything in existence? If I have this sheet of paper, so I'm doing some magic, you know, and the sheet of paper is being torn up, is there a sheet of paper in existence? There's nothing in existence. And that is the German view. And that is the vast of the common law world, that is the view, that on the basis of Article 5(1)(e), there is nothing that exists that you can take and enforce, because there is no award. If a judgment has been set aside, not remitted, it has been annulled, it has been set aside, is there a judgment? There is no judgment. There is nothing that you can do with that because it does not exist. So that's the purest view. So it sounds really exciting, interesting, and nice until you are on the other side of the debate or on the receiving end. So if we go back to Cromalloy and Egypt, or we go to Pemex, which I think actually represents what I want to say to you, where a US entity that had invested in Mexico with the opposing party was a Mexican government agency. And effectively, the Mexicans changed the law after the dispute had arisen. A award had been made, which would have left the US entity without any options. They were already too late to follow the administrative procedure. They already had an award that they could not enforce. So they went to the US. Their Mexican courts, up to the highest court, had set it aside. So if you follow my logic, and you're all sort of really listening to me, and you follow my logic, then there's nothing for Pemex to go back to. Yes, there is no award in existence. There's nothing for Pemex to go to the US courts to say, I have an award, can you enforce it? There's nothing, because it doesn't exist anymore. But why does it not exist anymore? Because the Mexican courts, that the government administrative agency lost the arbitration, retroactively passed a law so that Pemex had no options. Pemex could not go to an administrative tribunal because they were already out of time, but they had an award. Is it fair? Is that justice to say to Pemex, oh, sorry, your award has been set aside, you don't have an award, there is nothing to enforce? That is what we're debating. Those are the two extremes. So you have those who say, well, really, if the award has been annulled at the seat, there's nothing in existence. Ismail told us that. If you have a model law, if you're a model law jurisdiction, we have 11 or so of you on the continent, that is what your law says. Outside of the New York Convention, Germany is a model law jurisdiction. That is what the model law says, because the model law reproduces Article 5 of the New York Convention. What we also then have is we have all these African countries that have signed up to the New York Convention, so where we have Article 5(1)(e) in our laws. We're bound by that. But if you go back and read Article 5(1), start with Article 5. It's a may. It's discretionary, which means that even outside of Article 7, that you can establish one of these grounds, the court does not have to set aside that award. And so the question for us, because we tried to find a case on this question from the continent, from the courts in Africa, we haven't been faced with that question yet. Our courts haven't been faced with that particular question. And so we felt that, well, if our courts are faced with that question, how should they deal with it? So that's really what we're discussing this morning. And one of the things we're saying is that this links back to this question of, are you arbitration friendly or not? And so if we want to unpack it further, we need to define, what does it mean to say you are arbitration friendly? So it's true that the Rwandan courts have never set aside an award except recently, one award. We say that means that the Rwandan jurisdiction is arbitration friendly. Are we then defining arbitration friendliness in terms of how many awards have been set aside or not? So that's something for you to think about. The second point we wanted to bring to the fore is the fact that we need to look at our seats and what is our goal in arbitration. Ismail will come back and discuss that a little bit more. But to bear in mind that the top jurisdictions, depending on which survey you look at, so always be careful, depending on which survey you look at, the top jurisdictions, so if we talk about England, we talk about France, we talk about Singapore, Switzerland, and all of those places, they do set aside awards. They do set aside awards. Does that mean that people don't go to those jurisdictions? People go to those jurisdictions. They continue to go to those jurisdictions. So you can't then say that an award that does not meet some form of standard, because the role of the state, remember, the state is a gatekeeper. The rule of law, justice, ultimately. And that was what we heard in ICA. We were reminded that arbitration is actually a tool that should enhance the rule of law. We shouldn't hide behind privacy, confidentiality, and then just go rogue. And so the question for us that we do need to really think about is, if an African jurisdiction, an African court, is faced with this question, how should they deal with it? So Ismail is giving you the extreme end, one viewpoint. My job is to give you another viewpoint. There are two other viewpoints within the common law world. We have the US viewpoint, which is a little bit unstable. The way I say, from my own very personal opinion, is that the way the US courts deal with it, by the time you read the case law, it actually depends on how the judge feels, because it's a question of public policy. They bring it under public policy. So you all hopefully know about Getma v. Guinea. So Getma v. Guinea is an came out of Ohoda CCJ case, which the information is available online. So if you read the US court decision, where the award from Getma had been annulled at the CCJ, and the Getma took the award to the US courts to try to enforce it. And the US courts refused to enforce Getma on the basis that the decision wasn't too egregious for their public policy grounds. But if you look at the facts that the US courts had considered, if I was the judge, I will enforce it. You then contrast it with the decision of the US courts in Pemex, which is an American company, against the Mexican a government agency in Mexico. It wasn't enforced. They enforced an annulled award. The award was annulled in Mexico, they enforced it. And so there's a US party in Getma, forum non-convenience. It had no reasonable connection. There was no connection to the US economy or to the US courts. And there are a couple of cases that come out of that. We have, for the Nigerians, we have Baker Murray. You can also look at that, and that also went to the US courts. And so the point I'm making is that before the US courts, it's almost a lottery. You really can't tell because it's based on public policy. So what do we do in England? The English courts, we have 51E, and our law also has a section 68, where we talk about, it's not enough that you've established a ground to set aside an award, but we also sort of look at the level of injustice, if you like, that you have suffered. What have you really suffered? And that goes back to that 5.1 with the may. The fact that you've established that ground does not necessarily mean that the award has to be set aside. And so I'm going to read to you what our courts have said in the UK. So the court said that it would be unsatisfactory and contrary to principle if the court were bound to recognize a decision of a foreign court which offended against basic principles of honesty, natural justice, and domestic concepts of public policy. There's nothing in the New York Convention that says the court has to be honest and the court, talk about natural justice. But those are questions that will fall under public policy. But there is a clear guiding principle. And what the English courts have said is that the bar is really high. And why I particularly like the case where they talked about this is because it had to do with the Russians. And if you know anything about our economy, we desperately are missing the Russians, the oligarchs. So we need the Ukraine and Russian war to come to an end quickly. Our economy is on bended knees. And so this is something to do with the Russians. And the award had been set aside in Russia, and they wanted to enforce it in the UK. And the court says that the claimant seeking to enjoin the court to exercise its discretion to enforce an annulled award bears a heavy burden to establish not only that the foreign court's decisions were wrong or manifestly wrong, but that they are so perverse as for it to be concluded that they would not have been arrived at in good faith or otherwise than by bias. Which means, if the foreign court got the decision wrong, that is not enough. It is not enough. You have to show that the foreign court was biased against the other, the party seeking to enforce an annulled award. That is a very, very high bar to cross. But the English courts have sent a clear message. 5.1e, we would abide by. That will be our default. We will not enforce an annulled award. However, we retain our discretion to look at it. And my view is that that is the purpose of Article 5.1 being a discretionary provision. We go back to committee to give the enforcing court the opportunity to look at it. Not necessarily look at it and then disregard what it is you've looked at, but to look at it. So that my view, my plea to our African courts on the continent, is that it doesn't really matter what you decide, but let's have clear principles. So it's clear, there's predictability on, well, this is how high the bar would be, or this is the way we would look at it if it has any implications to our economy or our relationships, political questions, but not to become protectionist. not to become protectionists, such that as long as it's our own government agency, then that's it. We're going to set it aside. That is not being helpful and adding to international arbitral jurisprudence. So I'm going to be kind and allow Ismail to come back, and let me see what else he wants to add before I come back and see if I need to repair any damages that he may have done.
Extremely impressive. I really enjoyed your way of convincing the audience of your positions. One thing I would like to mention, as African states, we have an interest to become the seat of arbitration, at least regarding the projects and the contracts that are performed in our own states in Africa. Becoming a seat of arbitration, it has a lot of economic benefits for the seat. It also has other benefits instead of capacity building and being familiar with best arbitration practice. So the judges will have more cases to decide upon in setting aside proceedings. The local lawyers will plead more in international arbitration proceedings taking place on the African soil. The experts, the translators, the interpreters, the arbitration centers in Africa, etc. So we have an interest to become a seat of arbitration. So I will give you at least the example of Egypt. The Egyptian government has a policy when it is entering into a contract with a foreign investor or a foreign trader to propose and try to negotiate for Cairo, Egypt as the seat of arbitration. Sometimes I'm asked by public entities, how can we convince the foreign investor? The foreign investor wants the arbitration to be seated in Paris or London or Geneva. How can we convince the foreign investor? So there are the traditional arguments that we are a friendly arbitration jurisdiction. Our law is a model law-based law, that our local courts are familiar with arbitration. We have not set aside as many awards, etc. So these are the traditional arguments. But another argument, I advise them to tell the foreign investor that accepting Cairo, Egypt as the seat of arbitration, and this can apply to any African seat. I'm just mentioning Cairo because it's my country, but it applies to any African seat. Choosing an African seat for arbitration is a calculated risk if you are not sure of the safety of our seat. Even if our courts accidentally or incidentally get it wrong, it's not the end of the world, because you will still have the opportunity to enforce the award in France. So a very big opportunity, very big chances to still enforce the award against the Egyptian public entity in France, and a certain opportunity, although with a lesser chance, to enforce it in England or in the US. And it has happened before, like the Kromoloy case, for example. So this is an argument that could support the doctrine of the possibility of enforcing an arbitral award that has been set aside at the seat, whether we adopt the French approach or the English approach or the US approach, but not the German one. There is, I want to mention, to support what Emilia has mentioned, the Austrian court's approach, which is predictable and which is in between the French approach and the American approach, and British. The Austrian courts, they rely on a convention that very few European courts use, but it's a European convention, the Geneva Convention of 1961, which regulates in its Article 9 clearly when an award set aside at the seat can be enforced. So an Austrian court would enforce an arbitral award that has been set aside at the seat unless the reason for setting aside this award was the incapacity of one of the parties, that one of the parties was not properly notified with the nomination of an arbitration or with the arbitration proceedings, or if there was a due process issue, or if the arbitral tribunal has decided beyond the scope of the arbitration agreement, or there was an ultra petita issue. So this is an approach that is interesting, that can be considered. So it does not completely ignore the fact that an award has been set aside, like the French approach, and it does not set a very high bar or a very high standard like England, like the English courts. So, and to mention this, so the Austrian Supreme Court in 2005 enforced an award set aside in Slovenia because it was set aside in Slovenia for violation of Slovenian public policy and not for the 4 grounds that I have just mentioned, which are embodied in the European Convention of 1961.
So what I want to leave you with before we vote, we didn't say we have to vote, before we vote, is this. We've signed up to the New York Convention. The grounds contained in the European Convention on whatever international commercial arbitration of 1961 that Ismail is quoted applies to European countries and those that are part of the EU and EEA. And so that does not apply to us. But if we listened carefully to the grounds that Ismail read out, basically what the convention, the European Convention, was saying was to bring itself in alignment with Article 5(1) provisions. That's all. And so the point because Ismail is already conceded, to my view, so the point that we are saying to courts on the continent is basically stick with the Article 5 provisions. You signed up to the convention, stick to those grounds, do not add to the grounds, and even when such a ground is it's proven before you, to remember that it's a discretion that you have. And it's important for us to keep in view why parties have gone to arbitration in the first instance. And so the idea with going to arbitration is so that we want finality. And that is really important. And that's one of the major criticisms against the French view, which is the lack of finality. There has to be an end to disputes. And so you have an award, you made a choice to go to arbitration, you have the opportunity to choose your arbitrators, directly or indirectly, they have made a decision. Then you're bound by that decision. If for any reason you are unhappy with the decision or the process, and you have to go to court, then the courts are guided by Article 5 of the New York Convention. And we're saying stick with the provisions of Article 5, do not add to it, and we should be on safe grounds. And the last word to say on this is one of the things we had also discussed when we're preparing, is why we think this is important information to our courts on the continent, because of the colonial links to the various legal systems and the persuasiveness of decisions from the colonial relationship, the colonial courts. And so Francophone jurisdictions on the continent are generally very, very strongly persuaded by decisions from the French courts. And in similar vein is the common law jurisdictions from the English courts. And what we're saying is that we do want to see, if you like, an African court view. In the sense of courts from Africa, this is our position, this is our view, because our own circumstance is different from those of the other jurisdictions we've talked about. So the French courts can do a de novo, start afresh, review the merits, review everything, whether there's corruption or not. They can afford to do that. They will not miss cases. Arbitrations will still be seated in Paris and the other places. If one African court decides not to enforce an award on a ground that is frivolous, it's going to be talked about, we're going to be harassed at various conferences, and we're going to be hard-pressed to try to provide explanation. And we're saying to the courts, stick with what you have signed up to, which is Article 5 of the New York Convention. And so, for predictability, we want to be clear, we want to understand how you got to the solution that you got to. And we should be, we should be satisfied with that. So I hope, since I'm the one still standing, so I hope that you would agree with me that the position of the French courts is not the way to go for us. Remember, we're voting. Thank you.
Thank you very much. Thank you very much, Professor Emilia. Thank you very much, Selim. Personally, I had to take from the discussions is negotiators. You see now why those who resist to the seat in Africa, you have then what to say. That if our court misbehave, you have an option. I think that is a strategy for negotiators. Secondly, thank you, Emilia, for pointing out this. The way our court behave in our respective jurisdictions, we are always explaining. I recall the time of Get My Case. When it's get out, in the next, I think, 48 hours, how many articles produced. And it was not about OHADA, it was about all of us. It was about all our jurisdictions. We suffered from it, while if anyone here was a judge, could have found a different direction, possibly even enforcing that award partially. May I take one or two questions? I know it will not go far from two because the two academicians have clarified most of the questions.
So it's a debate, so I want to run the debate, but can both approaches be reconciled? Because the French approach is largely dependent on the French code, which doesn't list the fact that the award has been set aside as a seat as a ground to refuse recognition and enforcement, which is not the case in the modern countries where you have that ground listed. And to a point of the award being a dead later, it's set aside as a seat. And Emilia pointed out that the New York Convention says it's permissive to refuse on non-recognition and enforcement, which presumes that the award may not be dead if it's made.
Okay, I want to say thank you to Professor Emilia and Dr. Selim. Actually, what I have is not a question, but it's actually a comment. So I think the celebration of the Kigali International Arbitration Center is based on the impact of international arbitration in African development. So it's a very nice debate, but I believe as Africans, if we are here, it's because we want to develop our continent. So it's important for us to come to a consensus. In the debate, we disagree actually to agree at the end so that we could have foundations that will build up future arbitration proceedings for our continent. So my take is this. My take is that I believe that arbitration or the arbitration tribunal gets its powers from party autonomy. And party autonomy is based on the principle of pacta sunt servanda. It therefore means that the agreements between parties is binding to them and it is a law. So based on this principle, I don't think that for the seat, the court of the seat, to squash a particular arbitral award means that it is not still binding within the parties. So my take is that even though a particular court of the seat squashes an arbitral award, that arbitral award can still be enforced in other states based on the principle of pacta sunt servanda. So
Okay,
that
you.
is my take, and I would love us to have a consensus over it so that we could move forward and have a...
It's not a question, it's just a comment. Prof. Selim had convinced me, but coming from a common law jurisdiction, I've remembered the challenge that we're currently having in Kenya as to whether there's a right of appeal. And what Prof. Emilia asked, what are we enforcing when you go to the French court? Is this forum shopping? Is this a right of appeal that you're seeking? We've had that challenge in Kenya where there was a question of, is there a right of appeal to the Court of Appeal and subsequently to the Supreme Court? So there were conflicting decisions from the Court of Appeal saying, yes, you could go to the Court of Appeal, you couldn't go. So finally, through the Newto case, the Supreme Court decided. And what did they decide? Were there legitimate reasons to appeal? And that is why we are here before. And that's what Prof was arguing. What is these legitimate reasons that the court are finding for you to appeal? What are they looking for? A court has looked at the award, has decided to set aside. But then another court is saying, I'm looking at these legitimate reasons. Were there unfair determination of the rights of the parties? Those are the key questions we need to look at.
Thank you, Leila. There is last one over there, Mwine.
Thank you so much. Honestly, looking at this as a future chaos in arbitration, tell me if parties have an agreement of arbitration and they decide the arbitration, somebody takes the arbitral award to the courts of the seat, and the competent court review and set aside the award. Somebody considers to take that thing that has been set aside and enforce it in France. That one is likely to cause chaos on this continent of Africa. So, my take, I would say, respect should be number one. They should respect the parties done in the competent courts of Africa, and if the matter has been set aside, you can continue in courts, you appeal. And you set aside in the High Court, Court of Appeal and High Court, and Supreme Court. But please protect the chaos that is likely to happen.
Thank you very much, Mwine. You are a German. So that is the radical position of German court. So let's
Thank you.
Be brief.
It's be very brief.
Please, yes.
It's just a comment. I don't have a question. When Professor Emilia brought up her award and said she was going to tear it, which is the fact that it will be set aside, and I was listening to Dr. here speaking. When she brought it up, the question that flagged up in my head is, hold on a minute. If I know, now I come from a jurisdiction where we carry the litigation axe into arbitration, and I must always win. If I know that there's a likelihood, which is forum shopping to enforce. Why would I not say, well, you are setting it aside in your jurisdiction based on your own understanding? Does that now mean that if I go to another jurisdiction, I cannot enforce that award that was torn up? That is a challenge that I think I will want them to address. Number two is the jurisprudence of arbitration enforcement itself. Professor Emilia has referred to the Arbitration Act 1996, which is a very good legislation. But if you look at our continent, the underpinning jurisprudence, the underpinning legislation, does it also support Article 5? When in a jurisdiction like mine, you can set aside a word for misconduct, which is not defined. So I think there has to be a connection between the enabling legislation that gives effect to Article 5. Thank you very much.
The debate will not end because I remember we had the same debate in our recent conference that took place before just the Commonwealth conference here. And I remember taking the position of the French side approach, and given Kigali defending also the other side, it took, I think, 30 minutes again. I just want to ask Thierry and
I'm a moderator. You don't ask me any question.
The question is back to you. What do you suggest for us? Can we also take that risk, or we have to just remain on the side of the common law system that says that if it's decided, then leave it?
Yeah,
the French, because if countries, particularly African countries, are allowed to just set aside, sometimes on the basis of public policy. It has been argued, public policy is an unruly horse. What's public policy? And you know the French have always argued that international public policy, not just public policy based on the country. So I think it's really good argument that the sanctity of arbitration should be maintained. Once an award has been given, let it not be subjected to the whims and caprices of the country, who will then determine what public policy is, either by judicial approach or through the statutes. Let it be that arbitration is not, as a professor would argue, unpacked. Let us leave it as it is, and let us grow the process. Thank you.
Oh, thank you very much. May I perhaps use the opportunity of having the microphone and use 30 minutes to answer the question of what Rwandan court will take as a position. On my view, I wish to have a fast case to be submitted to Rwandan court. I believe, and if it's happened, we will even constitute ourselves as the amicus curiae to make sure that our court get it right. It's not about taking a radical position of right or left, but to treat it as case by case. That is my position. May I hand over this to both of you to answer and comment the question, which most of them were not questions, were comments. Emilia?
A quick one. Elodie, you're absolutely right. And as it relates to African countries, we need to be looking at the New York Convention, and that goes to the other question. So I know you're Nigerian. Yes, the ACA talks about misconduct, but the ACA domesticates the New York Convention. So yes. We're talking about the New York Convention, so Article 5 applies in Nigeria. And by virtue of Article 7, it should displace misconduct because it doesn't mean anything. All it would lead is that it would lead to higher standards, and the New York Convention, Thierry explains that. So that should bring us back to Article 5 of the New York Convention. if I think we can now take off our role play hats. My view is that, and this is my, on the point about the award, pacta sunt servanda cannot apply to the award because the award is not a contract. It's a judgment.
It's a judgment.
And so it's the status that it has is not given to it by the state. And so it is not, this is not a question of pacta sunt servanda. You've done that. You've done that's your arbitration agreement. But you have an award which has the equivalent status of a judgment given to it by the court, by the state. If the state recognizes this as equivalent to the judgment of its own court, then res judicata would apply, estoppel will apply. So it's a higher requirement. It's a higher sacrifice, if you like, because what you're then saying is that, well, we have an award and that's it. How? What if the due process was not respected? You know, there are fundamental questions against that award. Do you just then say, well, an award is being issued, an award is being issued, that's it? I think that, you know, just to make that correction. On whether you can go, that's what we're seeing. We see, and the Nigerians are experts, and thanks for putting money in the coffers of the English courts, because they would seek, they would challenge in Nigeria and run to the English courts to begin to try to enforce the same award. And IPCO and NPC, it's been in the, we've been fighting this since 2004, and various decisions have come out. And the way courts have dealt with this is that generally, again, falling back on this point of it's been set aside in Nigeria, the English courts will still look at it. And that's what's been happening with IPCO, and various decisions have come out from the English courts. If you're within the same jurisdiction, the law in Nigeria says that you will stay the set-aside proceeding, the enforcement proceeding, and deal with the set-aside proceeding first. And that shows you the point where the court's views are, because once the court sets it aside, there's nothing to enforce. And so they stay the enforcement and deal with the set-aside first. If they then don't set it aside, they effectively enforce it. So the point for me personally, I think I agree with what Thierry has said. We do need the courts. We need test cases to go before our courts. It has to be dealt with on a case-by-case basis. But what we just want is clearly reasoned decisions so we can understand and begin to build that jurisprudence. Ismail?
Thank you, Emilia. To respond first to Elodie, who was proposing to reconcile the two positions. First, as a general remark, the New York Convention is not intended to have a uniform application in the 170 states that have ratified the New York Convention. It just sets a maximum ceiling of control prior to permitting the enforcement of the recognition of, or the enforcement of an arbitral award in the state where such recognition or enforcement is sought. So there won't be any chaos if different African states adopt different approaches. But from my personal point of view, I would not recommend the German position, which is a radical one, and even you have seen Emilia was not very much encouraging the English court's position, because it takes into consideration the fact that an award has been set aside at the seat. It sets a very high standard to permit its enforcement, and this standard is to review whether such annulment was the result of a biased decision. So this is also a radical position that I think myself and Emilia would not recommend. The French approach, which applies Article 7. I think Article 7 should be taken into consideration. But even when the French courts apply Article 7.1 of the New York Convention, it still review whether the arbitral award is complying with the 5 requirements of Article 1520 of the French Code of Civil Procedure. The 5 grounds are more or less covering Article 5 of the New York Convention minus the ground of the annulment of an arbitral award at the seat, perhaps with a narrower scope, but you will see that the French courts, they control the competence of the arbitral tribunal, the regularity of the constitution of the arbitral tribunal, the respect of the arbitral tribunal of its mandate, the respect of due process, and the respect of French international public policy. So there is still some review that is done even in France. So I'm not suggesting that the African states would automatically apply the French position, but what I wanted to say that between the French position and the position suggested by Emilia, which is Article 5.1, we are not these two positions are not radical positions, and the African states can choose among them. Thank you.
So, thank you very much. And from the discussion, are we voting for yes or not, or we are voting for yes, no, and the middle position?
But the vote is between what and what? The French and the English? No. It's the French and Article 5.1, I think.
Okay, let's keep the two positions, yes and no, so to know who won, but at the same time, those who are neutral will also tell us, okay, who are in favor to enforce an award which has been set aside at the seat? Raise your hands. Raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 17. Ngwanza. Okay, 17. Those who are against. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9. Yes. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay. Thank you very much. Thank you very much for this panel have done well. Thank you very much.
And the moderator was fantastic.
Fantastic. Thank you. I can hand over to Maclean.